is that our country has enjoyed a different kind of government and a different kind of law from the rest of Europe. The rest of Europe has largely, not all of it, but most of it has undergone the great transformation inflicted upon it by Napoleon. And the imposition upon the nations of Europe of external sovereignty, written constitutions, and the Napoleonic jurisdiction, the Code Napoleon. Your country used to have a beautiful system of law, Roman Dutch law, which survives in the modern world, but only in the places which were part of the British Empire, because we stole them from you. That's to say, Zimbabwe used to be Rhodesia, and South Africa. Forget about that. The fact is that, the Netherlands are governed by a Napoleonic-style jurisdiction in which law is imposed upon people from above by the decisions of the legislature and works down into the capillaries of society. In my country, law is not largely, or wasn't largely, imposed from above, but was created in the courts. And indeed, to say that it was created is already to beg an important question. The British people regarded the courts of law, courts of the common law as it's called, as discovering the law. You take your dispute to a judge and the conflict that is really troubling you, you put it before that judge, and if he is impartial and proceeds according to the principles of natural justice, as they're called, then he will discover the legal solution, even if nobody has ever said it before. Parliament then has the business of ratifying this if it comes before Parliament, but much of our law has never come before Parliament. This is an extraordinary fact, that we have built up a legal system from below, from the resolution of the conflicts that occur between ordinary people, and only now and then with the intervention of the legislature imposing laws from above. You can understand this if you contrast the law of product liability in English law with the laws, all the laws and regulations about product liability which have been created by the European Commission and the European Court of Justice. We have one law, which is not even a law, it's a decision of the courts in the case of Donoghue against Stevenson, which tells you that somebody who is issuing something for sale in the general public is prima facie liable for all the adverse causes that will, adverse effects that would result from consuming it. That was a decision of the common law courts, and it has been sufficient to generate a fully developed system of product liability without consulting Parliament. Of course, Parliament comes in, but then when there is an additional difficulty, but that particular innovation saved us from all the problems that bothered European states in the interwar period. Right, so that, I think, is a very important point to remember, that our system of law is structurally completely different from those systems of laws applied in Europe, has great difficulty accommodating things like the decisions of the European Court of Justice, and certainly causes feelings of rebellion in in the minds of ordinary people when they find themselves subject to a regime of regulation which is vaster by 100-fold than anything that they've been accustomed to. And that, I think, is important because it gives people a sense that somehow we're being governed from outside by people who don't understand us, who only know how to regulate and don't know how to resolve conflicts. Regulations produce as many conflicts as they resolve. The common law only resolves things. But that's the second great feature of my country, which makes it so sceptical towards the European